Welcome to Common Sense. Common Sense is a series of shows featuring interviews with interesting people in our area that'll help us to learn in a clear, concise, and direct way who these folks are, what they do, and what makes sense to them and what doesn't. I'm Rudy Breglia, and today I'll be interviewing a judge's judge, Avon Lake's Municipal Court Judge, Darrel Bilancini, who's also a candidate for a position on the as a common pleas judge in Lorain County in 2022. Thank you for your service, Judge. Why don't you start us off, give us some of your background, tell us where you were born, where you've lived, how you've come to Avon Lake.
Sure. Well, I come from a family of 10 children.
Wow.
My dad was a fireman in Lorain, and my mom was a mom and a homemaker.
Okay, plenty of work.
Yeah. I was born on West 21st Street in Lorain, and at the time, our family had grown to, I'm the fourth oldest of the 10.
Okay.
And there were 8 children, I believe, at the time that we then moved from 21st Street to 8th Street.
Okay.
Into a 4-bedroom house, and there were 13 people living in the house because my mom's mom, my grandmother, was also living with us.
Okay,
so
cozy.
All the boys were in one room, all the girls were in the other. Soon after we moved, there were 2 additions to the family with my sisters, and again, 6 girls in the one room, 4 boys in the other. Lived there on 8th Street till I was married. I went to St. Mary's grade school and high school, which was right down the street from my house. Mm-hmm. And Lorain Catholic opened up when I was a sophomore in high school. So St. Mary's High School closed down. Lorain Catholic opened up. I went to Lorain Catholic for my junior and senior year. Graduated from high school, went on to John Carroll University in University Heights on the east side of Cleveland. Mm-hmm. And went to law school at Cleveland Marshall and graduated from there and went on to pass the bar and go on to a career of being a lawyer and then a judge.
What do you do in your spare time, Judge?
I don't have many hobbies, but one of them is to putz around the house, meaning do work around the house, do some maintenance. We have a house that we bought in 1985 in Avon Lake. Okay. And it was built in '65, so it's fairly good shape, but there's lots to do. So my hobby really is to work around the house. Gardening? Gardening, that's what I do. We don't vacation a lot, but I enjoy it. My wife does too, but my brother's a Finnish carpenter, and I learned some things from him, so I have some capabilities to do some work. Probably go a little bit beyond what I should do electrical-wise and plumbing-wise, but... we won't go into that. Yeah, I would consider those my hobbies.
Okay. What made you decide to become an attorney?
As I mentioned, I went to John Carroll, and during the summers, at that time in Lorain, the steel mill was open. The Ford plant was open. There were lots of jobs available for summer employees, kids coming back from college. And I know that the summer after I'm pretty sure it was the summer after my first year of college, the steel mill was hiring, the Ford plant was hiring. I went to the Ford plant and made it almost through their physical. Okay. And then they saw a scar on my left wrist, and it was a scar that I had from a surgery when I broke my wrist when I was between 10th and 11th grade. Okay. And so they x-rayed it there and said, oh, wow. We don't need you, because they were concerned about the liability and the injuring it further. So within a short period of time, I made application at U.S. Steel in Lorain and was hired, and they gave me a job in the Coke plant. And, it was an interesting summer.
What is Coke?
Coke is a product that is created when you you heat coal,
Okay.
essentially. So they have batteries that they have. It's a battery because it's a big box building that's probably 20 foot tall and I'm not sure, 30 foot wide and 50 feet long. And my job was to stand or work on top of that battery, which is an oven, and I was a lidsman on the battery, where they had holes in the top of the structure, and into which they would pour coal. I would put the lid on each of the holes, and it would burn for a period of time, and then
Pretty hot stuff.
The coke was created, and they'd push it out, and I'd have to then take the lid off and let them go through the process again. But I also did other functions. I wore long underwear, even though it was 90 degrees out, because the long underwear would allow me to sweat, and my sweat would go onto the long underwear, and that would cool my body. So that was the experience I had that summer. It caused me to really count the days before I went back to school. And next summer, I didn't work at the coke plant, but I worked in the steel mill as a laborer in the docks. And the next summer, I worked again at the docks. That gave me a lot of incentive to do something other than go to U.S. Steel. Because my older brother and my younger brother, just a year older and a year younger, worked at the steel mill. They didn't go to college. And I preferred to do something else. Yeah. So
it's dangerous and dirty work.
So my question to myself was, well, what next? And there were some fellas my junior year at college who were taking the LSAT test.
Okay.
And I thought, well, that's an option I'd consider. So I decided to take the test, and fortunately I did well enough on it to qualify to be admitted to several law schools. And then Cleveland Marshall was a good fit for me. It was close. It was relatively inexpensive. I got some grant money. And so I went to law school. Didn't know any lawyers. Again, my dad was a fireman.
I see.
I had never talked to a lawyer. Didn't know any of my friends whose fathers were lawyers. So I kind of went into it as an unknown, but I knew enough about it that I knew it was a profession that you can do good things for people. Mm-hmm. So that's really the reason I went to law school.
You made a really good choice.
I think so too. Yeah.
Okay. Well, tell us about the steps you've taken in your career.
Okay. Came out of law school, and at the time did know a lawyer, and that lawyer had an office in the Broadway building in Lorain, which is now the Ariel building. It's a hotel now. But I was on the third floor of the Broadway building, sharing space with this attorney, and fortunately I was able to get a position with the Lorain County Court of Common Pleas Juvenile Court. At that time was called a referee. They're now called magistrates. So I served as a magistrate for the next year and a half, being a judge. So the magistrate in juvenile court handled traffic cases and delinquency cases. So I would be a hearing officer, making decisions on guilt and innocence and sentencing juveniles, people who were under 18, to fines, and sometimes I'd put them in the detention home, and whatever the penalty was appropriate. Mm-hmm. So I had that year and a half experience, got to know some of the other attorneys in the community, got to know a fellow by the name of Jerry Savoy, who turned out to be my law partner for the next 30 years.
Wow.
So Jerry invited me to join his firm, and it was time that I moved on from the juvenile court and went with Jerry. And it was probably the best decision I made in my life, because Jerry was a great mentor. His business was primarily what's called insurance defense work. So I was a litigator. I was representing people who were insured by some of the companies that we represented, and I would represent those people in lawsuits that were filed against them that were covered by the insurance. So usually it's an automobile claim, sometimes it's a homeowner's claim, But then for the next 30 years, I was able to have a practice where I went to the common pleas courts in Lorain County, Cuyahoga, Medina, Huron, Erie County, primarily those adjoining counties to Lorain County, and was a trial lawyer. Great experience. A time came in 2005 when Jerry was thinking about retiring. I was thinking about what next, and I discovered that Judge Mackin, who was the municipal judge in Avon Lake at the time, was going to retire. And I considered running for election, something I'd never considered before. And I'm not a politician, not someone who had an interest in politics or actually even becoming a judge. I hadn't really thought about it. But the opportunity was there, and I thought, this is a good fit. The timing's right. It's something I had done in juvenile court as a magistrate.
So you fit right into it.
Yeah, and the other thing I did during the term of my career was to serve as a mediator and an arbitrator. So what a mediator is, the Bar Association would sponsor a mediation week. Typically it was in November, pre-Christmas, and people would want to settle because of Christmas expenses, those kinds of things.
Yeah.
So the court would assign the case to be mediated. I was among a team of mediators who would be available to assist parties, so that the plaintiff's attorney and defense attorney and their clients would come at a specified date and time, and they would meet with me and other mediators who would also volunteer to serve. And we tried to settle cases. And we had some good success. Actually, the percentage of resolutions was pretty high. So I had that experience while I was practicing. And then I also served as an arbitrator. An arbitrator is a panel of three attorneys who would hear a case and actually make a decision as to value. So these are all civil cases.
Right.
So we're dealing with money and liability. So the question would be, is the defendant liable for damages? And then if so, what's the extent of the damages? And so we would put our heads together, and if 2 out of the 3 would come to an agreement, hopefully all 3 of us come to an agreement as to liability and damages, then we would make an award. And it was not binding, meaning the parties didn't have to accept that. They could appeal to the judge, basically saying, we don't want to resolve the case with the number that the arbitrators came up with. We want to go to trial either before the judge or before a jury. I'd say 50% of the time the case was resolved with arbitration, but I had that opportunity to hear evidence, make a decision, and serve essentially as a judge. So with those experiences, I felt comfortable when the time came to run for the judge in the Avon Lake Court that I could do this.
You had enough diverse experience that
Right.
you could do that.
Yeah.
Now, what kinds of cases were they mostly? Automobile, or what other kinds of disputes?
It was primarily automobiles, but sometimes trip and falls, so property claims. Sometimes there were contract claims, but for the most part, the litigated cases in the common pleas court would involve matters, and typically so the negligence claims.
Okay.
Negligence occurs in a vehicle a lot of times. Negligence occurs when someone has a dangerous condition on their property.
And somebody trips and
Yeah, usually it's a grocery store. You'd find that the slip and falls. A lot of it had to do with weather conditions, so it's slippery surfaces or snow, or I guess you can think of lots of circumstances, and sometimes they're things you never thought of, but it happens, so you got to deal with it. So.
that's life.
Yeah.
Now you kind of told us how you prepared to be a judge. What are the qualities that makes a good judge? a judge's judge?
I suppose there's a couple things. One is respect. So you have to respect the system. You have to respect the people who are involved in the system, whether it's a criminal case or a civil matter. Patience is probably another good word that I would say a good judge has. I guess those are the two that I think of that I need to concentrate on every day when I hear cases. Knowledge of the law is very important, and that's the other thing about being a judge is I try to follow the law. Not all judges do that. Sometimes they decide I'm going to do my own thing, because nobody's really looking over your shoulder, except for the Court of Appeals possibly, but that requires the parties to appeal to the Court of Appeals. But again, following the law, being consistent, that's a big thing too. So that, and they go hand in hand, meaning follow the law allows you to be consistent. So you don't, if you don't follow the law in one case, and then the next case comes along, similar situation, and you got to remember, well, what did I do in that one? Or the attorney says, Judge, on that last one, this is how you handle this case, and why aren't you handling it the same way?
Sure.
So when I first started this job, that was one of the things that I thought I need to do, and some other judges had told me that just be consistent, and follow, but you can be consistent if you follow the law. So.
Now, you've been involved in many cases. So are there times when the law is a little on the gray side, and you have to kind of keep track of that case because to be consistent, and how would you do that?
I'm not sure the law is so gray. I mean, usually you can find support by researching the issue, and usually it's in one direction, one side. It's not because that's what the appellate system is about. If there's one court of appeals that decides it one way and another court of appeals that decides it another way, that's the case that goes to the Ohio Supreme Court.
Okay.
So ultimately, that court is going to make a decision as to which way they want to go, and so I wouldn't say that there's a lot of gray in law. From my perspective, usually there is one way versus another that a higher court has decided. So it's called precedent.
Okay,
and so
all right.
I'm bound by the law from the Ninth District Court of Appeals, and then if the Ninth District Court of Appeals has a conflict with another appellate district, then the case goes to the Ohio Supreme Court. And they make their way there on a regular basis, because that's what the Ohio Supreme Court does, is they decide cases. They don't have to decide any case that they don't want to receive. So they make the decision, okay, that's a case we want to deal with. Even though you appeal to the Supreme Court, they don't have to take the case. They can decide this is not something that is in conflict. There's settled law on this issue, and we're not going to relook at this case.
Understand.
Yeah.
What matters on a kind of do you preside over as a judge in Avon Lake? I guess I'm talking about civil and criminal.
Right. Yeah. Most of the cases we deal with are on the criminal side, and when I say criminal, I mean traffic and criminal. The majority of cases are cases that are, well, they're all misdemeanors, but the majority of cases are first-degree misdemeanors, and that would be an OVI offense, that would be a theft offense, that would be a domestic violence offense. I would say that's the majority of the cases that we deal with. The other cases are, so misdemeanor, the first degree is the highest or the most significant case, and the misdemeanor second degree, third degree, fourth degree, minor misdemeanor. The minor misdemeanors are traffic offenses, where there's speed, red light violation, those kinds of things. Fourth degree misdemeanor example would be disorderly conduct, persisting or intoxication, There aren't a lot of misdemeanors of the third and second degree. There's more misdemeanors of the first degree, which again are the thefts and the domestic violence and the OVIs. And again, those cases are in the high percentage of cases that we deal with. I move on to the civil side. So we traffic and criminal, but then we also do civil cases. But there's a limit. It's a dollar limit of $15,000.
Okay.
And most of those are credit card cases. So
Okay.
people don't pay their credit card bill, and they get sued. And usually it's in the range of $1,000 to $10,000. And unfortunately, most people don't respond to those lawsuits. So there's a lawsuit filed. The party who's making the claim gets service upon the defendant, so they find out where you are, and they send the U.S. Postal Service to you, and with a certified letter, and either you receive it or you don't receive it. But in any event, because you have the opportunity to get it, you're served, and therefore you have a responsibility to respond to the lawsuit. Most people who are sued for a credit card debt don't respond. They ignore it, and they are then subject to what's called a default judgment. And most of the credit card cases are resolved with a default judgment, so there's no trial. The party who's making the suit just files a motion for default. Attached to it is their evidence, and then the court makes a decision as to whether the evidence is sufficient, and then we grant judgment, and then it's a matter of collecting after that.
And then it's just so is it better for someone to respond when they're?
Yes, yeah, it usually is, because they can resolve it. The companies that are making these claims usually aren't the credit card company. It's a company that the credit card company has sold the claim to for pennies on the dollar, possibly. And so they want to just get something out of it. So the best thing to do is respond and negotiate. And unfortunately, some people can't. They can't even offer any money. But it's again better to at least know what's going on by responding, participating in the discussions. Usually, it can be resolved at a lower number. So I would suggest to anybody who does have to face that, come to court.
I think those are words to the wise.
Yeah.
Now, day to day, now we talked about handling different cases. Other than that, are there things that you have responsibility for as a judge, other than sitting and presiding over a case?
Yeah. Some courts have multiple judges. Let me just talk about Lorain County.
Okay.
So the municipal courts in Lorain County include Avon Lake on the northeast side, and then next to us is Lorain Municipal Court, which covers Lorain, Sheffield Lake, Sheffield Township. Move further to the west, Vermilion Municipal Court, which is a part-time court, meaning the judge is part-time. But what's different about Vermilion is they actually go into Erie County. So part of the jurisdiction for the Vermilion Court is in Lorain County, and part is in Erie County. And then going to the south, Elyria Municipal Court, and further south, Oberlin Municipal Court.
Okay.
So there's 5 municipal courts in Lorain County. What's your question?
Oh, my question was beyond case to case, what responsibility?
Yes, okay, I'm sorry. The point was going to be that Lorain and Elyria have 2 judges, and one serves as an administrative judge. In Avon Lake, where there's 1 judge, and Oberlin, where there's 1 judge, and Vermilion, where there's 1 judge, the sole judge acts as the administrative judge. So what we do, we're a boss. We hire and fire.
Okay.
Again, what's different about Lorain and Elyria's court is the clerk of court, who runs the filing system and the keeping track of everything.
Understand.
In Lorain and Elyria, there are elected positions. In Avon Lake and Vermilion and Oberlin, they're appointed positions. So the judge appoints the clerk of court, and essentially is the clerk's boss and the boss of the deputy clerks. And so we have other employees, the security officers, the bailiff, probation officers. So we're the administrative director of the court, and we make a budget, and we hire and fire, and we run the court. And let me talk about what's the involvement of the city of Avon Lake. Okay. The city of Avon Lake isn't the court's employer. They have no control over the court, but they have the responsibility of paying for the operation of the court.
Oh.
That's the way it works.
Okay.
So let's go to Cuyahoga County, Rocky River Municipal Court. They have the jurisdiction of several cities, but Rocky River has to provide a building for the court. Rocky River has to pay the salaries of some of the employees. Now, the system is set up so that some of the employees, the judge, the clerk of courts, the bailiffs, are paid partially by this so-called funding authority. So Rocky River, City of Rocky River is the funding authority for the court. The funding authority has to pay a portion of the salaries per statute. The county pays a portion of the salaries, as does the state of Ohio. The state of Ohio pays the majority. So so my salary is paid by those three entities: the state, the county, and the city of Avon Lake. But going back to your question about what other functions we have, we work with the funding authority to keep the building up, to share the building in Avon Lake. We're in the building with the police department and the fire department. We share parking lots and those kinds of things. But so those are the other responsibilities that the judge has.
It sounds like kind of a complex responsibility.
It can be.
You've got to run.
Oh, it can be. Yeah. But I've been so fortunate that the mayors that have been in place since I started in 2006, they've all been terrific, and the police chiefs terrific.
It runs very smoothly.
Yeah, we get along. There's no politics involved. There's no. I'm easy to get along with, and fortunately for me, they have been also, and things have run smoothly. We've really never had any disputes. We work things out, and again, I'm very fortunate.
Okay.
This is a job that, as you mentioned, I'm hopefully going to move on to the common pleas position in a year and a half. And this job is sought after. There are a lot of people who know the how smoothly we operate, and they want to be in my position.
Be part of that.
So,
yeah. What pleas and penalties occur in your Avon Lake court?
As far as pleas, there's 3 pleas in all courts, and that is guilty, not guilty, or no contest. Guilty is an admission of your guilt. Not guilty is I'm not guilty, and I want a pretrial or a trial. And then no contest is similar to guilty, but it's not an admission of your guilt, but is an admission of the truth of the facts stated in the complaint. It can't be used against you in any subsequent civil or criminal proceeding. So that's the language of the rule. It's set up so that people can avoid having to. It's really for civil cases. So it's a criminal case, and it's a matter that could result in a civil matter. So somebody's going to sue for money, and you want to avoid admitting your responsibility. So the law allows you to plead no contest, and the court finds you guilty, but you don't admit your guilt. It's really not appropriate in most situations. It's usually appropriate in a traffic case where you've got maybe an intersection collision, and one person says, I wasn't at fault. The other person says, I wasn't at fault. He was at fault. But and maybe you share responsibility because you're both negligent in some way. So you don't want to admit I'm guilty, and you don't have to with a plea of no contest.
Okay. What about penalties?
Penalties, as I indicated, range. There's the misdemeanors, first, second, third degree, and then minor misdemeanor. The definition of a misdemeanor is a charge that has a maximum penalty of 180 days in jail. So 6 months in jail is a misdemeanor. Beyond that is a felony. The municipal courts don't litigate felonies. That's the responsibility of the Common Pleas Court, which is each county, 88 counties have a Common Pleas Court. It's county-wide, and again, there are certain criminal offenses that are felonies, and they automatically go up to the Common Pleas Court. I'll go through the levels. The misdemeanor of the second degree, $750 fine maximum, 90 days jail. Third degree, $500 fine, 60 days jail. Fourth degree, $250 fine, 30 days in jail. Minor misdemeanor, no jail, $150 fine, maximum penalty. There are some community service levels that apply to each, meaning the court, as opposed to imposing a financial penalty, you can order that they do community service. And so those are the levels of penalties for misdemeanor cases. The court also has the authority to be creative, and so even though the statute puts these limits on these levels of misdemeanors, they also provide the judge with the opportunity to impose the requirement that people get treatment. So a lot of the cases we have are alcohol and drug related.
Okay.
So the court can order as a part of probation. So we impose jail and suspend the jail on condition. And these conditions are all these things that the court can do to try to help the situation.
Right.
Whether
right.
it's, again, having them assessed for alcohol and drug issues and then following through with the treatment recommended by the experts who make the assessment. And again, it's as creative as a judge wants to be. So you've seen some stories in the paper or the news where judges have people hold signs up and say, "I'm a thief," or whatever it might be.
Okay.
I don't do a lot of that. I do some things, but I'm not that creative, and I'm not sure that it's always. Sometimes it's just advertising for the judge, but
Yeah, you want the best for the.
right. I'm trying to improve these people's situation, and you really have the opportunity to help people. And let me move on to. You asked before. Well, what are the usual cases that we deal with? One of the more usual charges that all municipal judges in Ohio deal with are driving under suspension. There's like 50 ways that someone can lose their license and have it suspended. The biggest one probably is when you're pulled over by a police officer for a traffic stop, you have the responsibility to show that you have insurance. And if you fail to show that you had insurance, it'll be noted on the ticket, and it'll be sent down to the Bureau of Motor Vehicles. And if you don't show that you had insurance, then you're subject to being suspended under a suspension called a non-compliance suspension. So
Okay.
you weren't complying with the law that said you have to have insurance. And that'll result in a suspension. And it'll require you to, and on the first offense, it'll require you to get what's called an SR-22 bond. So it's a bond that the insurance company provides, that the insurance company says to the state of Ohio, if this person who now has insurance doesn't maintain their insurance by paying the premiums, then we'll notify the BMV that they don't have insurance anymore and they'll be suspended. So most people who don't have the requirement for the SR-22 bond, the insurance company, if you stop paying your premium, won't notify the BMV because there's no responsibility on the insurance company's part to contact the BMV. But if you have this SR-22 bond, then they're responsible to contact the BMV, and then you'll be suspended again. So a lot of people are under these suspensions. And unfortunately, they bring themselves to the attention of a police officer somehow. And then they're charged with driving under suspension because the suspension has been
Sure.
put into effect. And the penalty for that is up to a fine of up to $1,000, and some suspensions, not the non-compliance, but some other suspensions, are punishable up to jail. So we deal with that all the time.
I
And
see.
part of the reason for that is because police officers have the ability, when they go out and observe traffic, they have the ability to look at your plate. And in fact, there's some machines that will look at your plate
Yeah.
and then provide that information to the police officer who's sitting in his cruiser. It'll go to his computer. It's a laptop that's usually sitting next to him, and it'll pop up who the registered owner of that vehicle is, and it'll provide a picture. And it'll provide information as to whether or not they're suspended or whether they have a warrant for their arrest. And the officer can then pull them over. Even though they didn't
Do anything bad.
break the law,
Yeah.
they didn't have a traffic offense, the law allows the officer to pull them over, determine whether or not that person who's driving is the owner of the vehicle. Many times it is. And then they can charge them with the driving under suspension as a result of that, tow their vehicle, and the expenses rise.
Yeah,
And
it
so-
goes real downhill right away.
And so that person then is required to go to court and deal with the situation that they're in. And a lot of people are driving because they have to go to work,
Sure.
and they choose to take the risk. And unfortunately, they somehow come to the attention of a police officer. So that's the majority of what I see in Avon Lake. That's the majority of what all the judges in Lorain County, and I'm sure throughout the state of Ohio, because I go to judicial conferences where there are judges throughout the state of Ohio who say the same thing.
I see.
Yeah, they
I
have to
see.
deal with these driving under suspension offenses.
And with these automatic readers of driver's license, license plates on cars, I think you'll see even more of this.
Yeah, no, that's very true. Yeah, so one of the things we can do is to try to help them get their license back, because a lot of these people are clueless as to what,
Yeah.
because it's been so long since they've had a driver's license.
Yeah.
And sometimes, we print out for them when we know they're coming in, we know they're charged with the driving under suspension. We'll print out from the BMV website that we have access to the information about, the things that they need to do to get their license back, and I'll go through it with them, and I'll highlight it, and I'll number it, and I say, you do this first, this second, this third, this fourth, and they'll say, I didn't know that.
Yeah.
So I guess
So you're helping them.
it's really a sense of I did something good today, and I've talked to other judges, and they feel the same way, that you can really help them because it's a burden that they carry all the time, and if you can lighten that burden and get their license back, it really makes their life a lot simpler. And it's amazing to me how these people are clueless as to what's going on in their life, and that they haven't been able to get their license. So it's really a good feeling when I can help them out and get it.
Well, I think it's a matter of living an orderly life. You get the notice from the insurance company that the bill is due, and you have to pay it, and then they send you these tickets that indicate that you have insurance, and you need to put those in your car, and all these steps you need to take, and be orderly about it.
A lot of people just bypass that because they don't have the ability to organize their life, and sometimes I'm surprised they even made it to court. And sometimes they look like they just got out of bed, but I try to be sympathetic and understanding about their situation.
Yeah.
But
Human beings. What is contempt of court? You see that on television all the time.
It's simply failure to follow an order of the court. So it could be lots of things.
Okay.
Contempt in the courtroom is another thing where you don't fail to follow an order, you disrupt the court somehow. And there are penalties for that. There's different rules for contempt in the courtroom or outside the courtroom, direct or indirect contempt. And again, it's simply failing to follow an order. For instance, I had a case yesterday that I dealt with. It was a small claims case, and I didn't deal with small claims. Small claims is a division of the court, municipal courts, that deal with cases where an attorney doesn't need to be involved. The rules of evidence don't apply. The limit on the claim is it used to be $3,000. It's now $6,000.
Okay.
So someone can sue someone for money damages in the small claims court division of the municipal court, and come to court. Once they file the lawsuit, it's without an attorney, so they're usually handwriting their complaint, and it's very simple.
Mm-hmm.
They pay $75 to the clerk. Service is made upon the defendant. There's a date for a hearing set. They show up at the hearing. They present their case. They get a judgment, or they don't get a judgment. And in this situation I was dealing with yesterday, the person, it had to do with a bridal dress. And the mom of the bride had purchased a dress, and it was supposed to be provided and wasn't, and the small claims complaint was filed. The defendant bridal shop out of Sheffield Village didn't show up. A judgment was given for, I believe it was under $1,000. And the mom was trying, actually mom wanted the dress, because I asked her yesterday, have you had the wedding yet? And she says, it's next month.
Oh boy.
And apparently they're not, they bought another dress, but she was hoping to get it. But now she's hoping to get her money because she had paid for the dress. The bridal shop didn't show up for the hearing. The bridal shop didn't show up for a hearing on the request for a debtor's examination. So what the court does in these small claims cases is send out a questionnaire to the defendant saying, the court orders you to provide information about your assets and your liabilities, so that the plaintiff who has this judgment can make an effort to collect against you. The bridal shop didn't show up for the hearing. I found them in contempt for not following the court's order, and the order was that they provide this information on this paper that we sent them to provide their information.
Understand.
And I then found that as a penalty for the contempt, it's $250 fine, that's the maximum, and up to 30 days in jail. So it's similar to a misdemeanor of the fourth degree.
Wow.
So I ordered that the defendant be served 30 days in jail and pay a $250 fine. They can purge their contempt if they show up at another hearing that we've scheduled and provide us with the information that we asked for. So we'll see what happens. I then included the owner of the bridal shop, and I think that'll get his attention.
Yeah, I would say so.
So he's to serve 30 days in jail and pay a $250 fine unless he shows up and purges his contempt. The plaintiff told me that she went by the shop yesterday, and I'm probably identifying the shop by telling you all these details, but went by the shop yesterday and found that it's operating. They locked the door, but it's by appointment only, but they were actually inside meeting with clients. So there is somebody operating the shop, and we'll see if he shows up.
Okay. Well,
That's contempt.
I would say staying away from contempt of court is a real good idea. Are there any typical things that people do that stand out in your mind as this is typically why contempt of court occurs?
It's usually not showing up. Showing up for a hearing. Yeah.
Okay.
And that's when a warrant. I think one of your questions was about a warrant.
Yeah.
So that's when a warrant's issued. So generally, there's a thing called bond or bail, and usually there's no bond or bail in a case that you're just summoned to court. So there's an order, and it's usually on a traffic ticket or even on a complaint. The police officer who writes the complaint indicates a date for you to appear, and it's a summons. You're ordered to appear pursuant to this summons. You fail to appear pursuant to that summons, and then you're subject to being arrested. Then there's a warrant for your arrest. It's also called a capias, C-A-P-I-A-S.
Okay.
It's an order for the police officer to arrest this person. Usually they're taken to jail first before they're brought to court, because the court's usually not in session at the time they get arrested. But that's another form of contempt, failing to appear, resulting in a summons, or excuse me, resulting in a capias and a warrant for their arrest.
So, okay.
Also something you want to avoid.
Yeah, word to the wise.
Particularly on a weekend.
Yeah, right. Now, I would think repeated offenses, I think you talked a little bit about that before, that, you know, if you do something repeatedly, then the penalties go up.
Right, and that's most obvious in an OVI charge. So first offense OVI has certain minimum sentences. So it's minimum sentence on an OVI is 3 days in jail. So OVI is operating a vehicle while impaired or under the influence, or it used to be called DUI. So 3 days in jail, $375 fine. These are the minimums. 1 year license suspension, 6 points on your record. If you're convicted of an OVI, if in the next 10 years you are charged with another OVI for which you're found guilty, then the penalties are what's called enhanced, or they're greater. So instead of 3 days minimum, it's 10 days minimum. $525 fine minimum. 1 year license suspension, but it goes up to 7 years, and if you have privileges to drive during that suspension, you have to have an ignition interlock device installed in your car and the restricted yellow plates. So when you see yellow plates, that's a person who has multiple OVIs, convictions, but was given the privilege to drive during the suspension, limited privileges to drive to work primarily, but they have to have the yellow plates also as a condition of their privileges. And that's to alert everybody, including police officers, that this is a person who's had a couple OVIs or more, but given the permission to go to work. So if the officer pulls them over, question them about, are you within your privileges? If so, you can move on. If not, they're charged with driving under an OVI suspension, which is a first-degree misdemeanor, et cetera. Let me move on to it's like a third OVI is unusual. I mentioned before that the maximum penalty for a first-degree misdemeanor is 6 months, and anything beyond the 6 months is a felony. The exception is a third offense OVI. So third offense OVI carries with it a maximum jail sentence of 1 year in jail. So it's still a misdemeanor. It's called an unclassified misdemeanor.
Okay.
Because it's something other than a first, second, third, fourth minor. The minimum on a third offense is 30 days in jail, up to 1 year in jail, fines of $850 minimum, license suspension 2 years to 12 years, 6 points again on your license. So those are that's an example of the increased penalties for multiple offenses.
Right.
Yeah.
I guess as a society, we realize how significant driving while intoxicated is.
Sure.
It's life and death situation, right?
Yep.
The,
And in fact, we had there was a aggravated vehicular homicide that took place in Sheffield Village. It hasn't been reported in the paper, surprisingly. It happened about 2 weeks ago. There was a gentleman who lives in Lorain who was observed driving in Lorain and coming into Sheffield Village, which is a part of our court's jurisdiction. And it was at about midnight, and his lights were off. And someone who witnessed his bad driving had already called the police. And by the time he got further on Colorado into Sheffield Village, his lights were still off. He was driving badly. He went left to center, and he hit a vehicle that was occupied by a gentleman and a female passenger. The gentleman died as a result of his injuries. She was injured severely. He appeared in the defendant, the driver, he appeared in our court this past week. He's under house arrest. He's under supervision. He works at Ford Motor Company. It was his, trying to think,
multiple.
He had prior. He actually had a prior OVI outside that 10-year look-back period, but he had some other OVI. They were all in the past. He's a 49-year-old gentleman. When he was 21, he had an OVI, and later in his 20s, he had some other OVI charges in Lorain Municipal Court that were reduced. I'm not sure what the facts were, but they were reduced. In any event, yeah, he killed this fella, and he's going to be charged with a felony of the second degree, 2 counts, and he'll go to the common pleas court once he moves out of our court. We have a preliminary hearing scheduled for this next week, where the only thing we do is to determine whether there's probable cause for him to be charged with the aggravated vehicular homicide, and then we pass it on to the common pleas court. The bond's already been set, again, being under house arrest and having to be supervised by the common pleas court. We're letting him go to work. He's going to go to prison, assuming he's found guilty, and the facts that I've heard certainly support his guilt. So, yeah.
Understand. When do you have jury trials in Avon Lake?
We do have jury trials. It's very uncommon that most municipal courts have jury trials, simply because they are costly for the parties, particularly in a civil case. So it's very rare in a civil case, because the cases aren't that, as I mentioned, it's a $15,000 cutoff, so it costs a lot of money to try a case with an attorney. But we do have jury trials. We have one set for next month. It would be the first that we've had in approximately 2 years because of COVID.
Okay.
Lots of cases have been resolved, trying to avoid having to bring jurors into the courtroom and subject them to,
different precautions.
Yeah, yeah. And throughout the state of Ohio and throughout the country, there aren't too many jury trials taking place. But we have to accommodate, because if someone wants a jury trial, they'll get a jury trial. But we have to put up plexiglass separators and maintain distance, and some buildings aren't set up so they can accommodate. So some of the courts in Calgary County, for instance, the Justice Center would not accommodate a jury trial, so they're moving into other buildings outside the Justice Center where they can just have a large room and space people out. And they're having jury trials, but they prefer to avoid it because it's so difficult to do.
How many elections have you been through?
Fortunately, I've been through one.
Only one, okay.
Yeah. And that was back in 2005, and I was elected to take the position in 2006. All judges in Ohio have 6-year terms. So whether you're a trial judge in a municipal court or a common pleas court or an appellate judge in the district courts or a Supreme Court justice, they all have 6-year terms. So they're subject to election every 6 years. I've been subject to election every 6 years. Unfortunately, no one was interested in
running against you,
taking my position, and have to run. And it's difficult simply because it takes time, it takes money. As an attorney, you're taking time out of your schedule where you can earn money, and you got to run for election. So I've been fortunate that for the last 12 years I ran unopposed. But you still have to run and just get one vote. My wife votes for me, so.
Well,
I do too.
That's fortunate. You do too. Okay, that's great. Now, a little bit different.
At least I think my wife votes for me.
Well, you never know.
Yeah.
Should judges continue to be elected, or should they be chosen some other way?
Yeah, that's a real good question, because most states do not elect their judges. Ohio is in the minority. It's hard to say. Unfortunately, for judgeships, it's a name game, so it's not necessarily whether or not you're qualified or not. It's like in most elections, people walk in and vote, and if either they know who they're going to vote for in advance, or they don't, and once they get there, they look at the names, and I know that name. I've seen that before. And unfortunately, they may end up with somebody who's not so good. And that's happened, I know, in Calgary County. The Russos and the Gallaghers and the O'Donnells, people with those names run for judge, even though they may not be qualified or the best pick among them, because they know that there's 4 Gallaghers in the Court of Common Pleas. There's 3 Russos, you know.
Kind of tells you something.
Yeah, and I'll say it. There was a Russo, this was probably 10 years ago, who was running for Common Pleas, and the plain dealer determined that this person is not qualified to be a Common Pleas judge. And so they actually came out and said, don't vote for this Russo because she's not qualified. They had to go to that extent because it happened. So the question is, should judges be elected? I think it's good if we can avoid that problem. Then once they become a judge, I'm thinking that as opposed to having to run again, then lots of states have this system where there's a panel of some sort that determines whether or not this judge qualifies to be reappointed to this position. I don't exactly know how it works, but there are some states, and I think the majority of states do it that way. I don't have a strong opinion because I really haven't researched the pros and cons. Yeah.
Well, it's certainly a difficult question.
Yeah, it is. Yeah.
Tell us a little bit about the courts in Lorain County and the state. You know,
Sure.
you talked a little bit about Supreme Court and how that works.
Yeah. Again, there's the trial courts, and I mentioned that there are 5 municipal courts, which are trial courts in Lorain County. And then the Common Pleas Court, as I mentioned, in the 88 counties, each one has this Common Pleas Court system that covers the entire county, no matter how big or small. And then they have divisions within the Common Pleas. And these are trial courts. They have hearings. There's domestic relations. And in Lorain County, the domestic relations judges also cover the juvenile division. So there's a domestic relations division, there's a juvenile division. The judges, there are 3 of them in Lorain County who do both. They deal with the juvenile cases, they deal with the divorces, domestic relations cases.
Okay.
And then there's the probate division. There's one judge in Lorain County who handles the probate cases. And then there's what's called the general division. There are 6 judges who deal with the felonies, the criminal cases, as well as the civil cases. There's no limit to the monetary claims that can be made in the civil divisions of the general divisions of the Common Pleas Court. Some other counties have a different combination. So maybe they're probate and domestic. I think Erie County has that division, and maybe a separate juvenile division. They all have the general division, although sometimes there's one judge in the entire county, it's a smaller populated county, who does everything. So he's the probate judge, he or she is the domestic relations, juvenile, and general division judges.
Just changes hats.
Yep. And which is a really tough job because you need to know the law in all those areas, which is really complex. Yeah. So those are the trial judges. And then, as I mentioned, there's the 9th District Court of Appeals, which covers 5 different counties, which includes Lorain County. They are the judges who they don't hear evidence. It's not a trial court. It's an appellate court where what they hear in a three-judge panel, they hear appeals. So all appeals go up to the Court of Appeals. It's not discretionary. They take everything that's appealed, and they have appellate briefs that are filed. So there's requirements that your argument be put on paper and submitted to the judges who have that in advance of a hearing that they have, where it's an oral hearing. So the parties, the attorneys usually, sometimes it's a pro se party who isn't represented by an attorney. They appear for one time where they present oral argument. So in addition to the written argument, they present an oral argument. There's a limited time for them to say what they're going to say, and then the judges say, we'll take this under advisement, meaning we'll take some time to study this.
They ask questions, right?
And they do. Yes. It's typical that they ask questions. Sometimes they don't. Sometimes they ask a lot. Sometimes they've made their decision in advance of the argument. Sometimes not. But then they make a decision. It's got to be a majority decision. So at least two of the judges have to agree as to the outcome, and they write an opinion, and that opinion is then sent to the parties, and that's their decision.
Okay.
And sometimes it's sent back to the trial court. If the trial court didn't do something that the Court of Appeals says, you should have done this, go ahead and do it now.
Okay.
Sometimes it's just an affirmation of the decision that's made by the trial court, whether it's the judge making the decision or whether it's a jury making the decision. Again, sometimes they affirm, sometimes they reverse, and they say the other side wins, end of case, or they say, Judge, you need to do something different this time, do it again,
Okay.
Consider this next time. Sometimes it's sent back to the Court of Appeals, that's unusual, and then there's the Supreme Court. And as I mentioned, that all cases don't have to be received by the Supreme Court. It's their discretion as to whether or not they take the case. That's most of the cases that they deal with. Sometimes there's a direct appeal from the trial court to the Supreme Court. It's very limited, but sometimes an issue goes directly to the Supreme Court and they bypass the Court of Appeals. Again, it's limited, but that's sometimes the Supreme Court hears those kinds of things.
Mm-hmm.
Yeah.
Okay. Well, can you tell us why you're running for Common Pleas judge
Sure.
right now at this time?
As I mentioned, 30 years plus when I was with my law partner, Jerry Savoy, we handled the cases that we litigated. They were mostly in the Common Pleas Court. So my experience prior to taking this position as a municipal court judge was primarily in the Common Pleas Courts. That's where I lived. That was where I worked. I'm comfortable with it. I think I know how to handle those cases. I've not had the opportunity to handle those cases. I guess I should say, the viewers may not know, that the Avon Lake Municipal Court judgeship was part-time since 1957. Judge Jensen served for 24 years, Judge Mackin served for 18 years, and I served from 2006 to 2014 as a part-time judge. That meant we can practice law and also be the judge.
Okay.
In 2014, the caseload had increased significantly, so that it was time for the judgeship to become full-time.
Okay.
So we made it. You go through a process of have to change the law. So at the time, Matt Lundy was the state representative. I spoke to him. Gail Manning was in the Senate. We spoke to her, and they both agreed it was appropriate that the Avon Lake Municipal Court judgeship become full-time. We spoke to the Bar Association, we spoke to the county commissioners, we spoke to city council. They all agreed. And in order to change the law, the Supreme Court, and get the Supreme Court's blessing to do that, you need all these other groups to say, yeah, it's time. And so we were able to do that. And it was within 6 months, which is a pretty short time because it requires the governor's signature and then 90 days afterwards. So we moved on this very quickly. Everyone was in agreement, and we became full-time. So I haven't practiced, I guess my point is that I haven't practiced law since 2014. I was practicing up till then. And most of my experience was in the Common Pleas Court. And the other thing that is going on now, to answer your question about why now, my term ends in 2023.
Okay.
In October 18th of 2023, I turned 70.
Okay.
You can't run for election. You can't take the position once you're 70. So I missed.
I got you.
If I was in my mom's womb for another 2.5 months,
It would have worked out.
then I would be able to run for election and take this position and maintain it for another 6 years. I can't do that.
Okay.
I enjoy being a judge. I would enjoy being a judge in the Common Pleas Court. I can run for that position the year prior, so 2022, next year. There's a position that's opening in the Common Pleas Court in Lorain County. Judge Mark Bilancini is going to retire, and I would like to throw my hat into that ring to see if I can be elected to that position.
Okay.
I would, again, I would enjoy it. I think I would be good at it. I've had the experience, and that's my selling point to people is I've done this now for years and been educated about, by the Supreme Court as to, how to be a good judge, and so we'll see. But
Okay.
that's the plan, and that's the reason.
Well, you have such a young attitude and so much energy. I would think the citizens of Lorain County would do very well
Yeah.
to have you as a judge.
It's still going to be a name game, so I've got to get out there and get my name out there, so people, when they walk into or they make a decision at home when they do the absentee, that Bilancini, I know that guy.
What surprised you about being a judge when you you were an attorney and then you did these other things? What kind of surprised you about being a judge?
I had, the people who are watching this can see that I've got your list of questions here, and I wrote down some notes for that. And I was trying to remember what I wrote down, and what I wrote down was what surprised me is how, and it continues today, that I, every once in a while, I'll think to myself, God, I'm not good enough to do this job. They call you Your Honor, and they all rise when you walk in the room. Mm-hmm. I still haven't gotten used to that, even after 16 years doing this job. But I suppose the surprise would be that I still don't think I'm good enough to do this job. But
Okay.
I know that I am, but it crosses my mind.
Well, being humble, there's nothing wrong with that.
Anyway, that surprises me that I continue to think that. But it happens, and then, so anyway.
Well, the reason I'm wearing a tie today is because out of respect for your office and for you.
Well, that's the thing about, it's the respect for the office, certainly not respect for me, but yeah, and that's important. That's important because that, it allows me to then more easily show respect for the people who appear in front of me, and it should force every judge to do that, to pay respect to the system, pay respect to the parties, and just do your job.
What cautions does a judge need to be conscious of, both in his professional and personal life?
I have to read my note on that one too. I wrote, put yourself in the position of being embarrassed by your actions in or out of court. And I guess what I meant to say by that was, you got to be, you're in a position of high regard, and you have to do things that maintain that position. So don't be goofy. Don't be well, goofy isn't the right word, but don't do anything that you'll regret. And every once I'm pretty tame guy. I don't do anything that's crazy. I don't drink. I drink some, but I don't drink.
Drink and drive.
And drive,
for sure.
certainly. But I mean, maybe when I first started this position, I was more susceptible to temptations for doing things that weren't appropriate, but not anymore.
Do you get discouraged sometimes? You
I
see
really
a lot
don't.
of.
When I read that question, I don't just get discouraged. It's a job where there's a lot of satisfaction in, as I mentioned, every day to go in, you can do something good for people. I guess the discouragement would be that you're not successful. if you try to help somebody out who, it's usually a drug or alcohol issue.
Yeah,
And,
right, right.
people have died who have appeared before me because they've overdosed, and that's discouraging, I suppose. And alcohol issues, they've been in front of you once, you tried to help them and put them in a good position, they come back, that's discouraging. But it's the way it goes.
Human nature, once those drugs get a hold of you, get their hooks into you,
Right.
it's very difficult to come out of it.
No question, no question.
What advice would you give someone who's wants to become a lawyer, a judge?
Yeah. You got to get elected, as we talked.
That's important.
And so therefore, you need to be involved in the community. You have to be involved in your church if you go to church. You have to, people have to know you. People have to know your name to be elected. So that's one as far as getting elected. But then in terms of doing your job, know the law.
Get the kind of experience that you got.
Sure. Hopefully have the experience of being in a judicial position. One of the other things is someone who's an athlete has the advantage of being involved in sports, and it is a sporting game to some extent. The other, I guess, I think you get to know what people are like when you play sports. When you basketball, do they pass? Do they share the ball? Do they follow the rules? Do they call fouls on themselves? When you're playing pickup, you learn a lot about a person when you play sports with them. And I played basketball, so it's usually in a basketball game. Boy, you really fast. You get to know what this person's like. Whether they box you out, too hard, and all that stuff. So,
play it close.
Anyway, play by the rules, all that.
Mm-hmm. Well, the question I always ask towards the end of the interview is, what makes sense to you and what doesn't? Do you have any thoughts on that?
My response was the golden rule: do unto others as you would want them to do to you. And as a judge, I think if that's something you need to keep in the back of your mind, treat people the way you want to be treated. So the respect that comes into play, the compassion, and all that. It's not to say that you won't punish them, because I suppose if I was in their shoes, I benefit from the punishment. So I try to take that into consideration. This person needs to go to jail because they need to see the inside of the jail, and because they haven't seen it. They've been committing these offenses, usually it's other courts, and I'm looking at their record, and they say, this person never went to jail. They need to go to jail.
Yeah. It's a benefit.
And even on a first offense, sometimes, shoplifting case, I think this person needs to see the inside of the jail for at least a day. So I'll sentence them to a day in the county jail, and that's an eye-opener. And people have come back afterwards and said,
that was good.
That helped. I needed that.
Okay.
So
wake up.
Yeah. So treat them the way you would like to be treated yourself. And again, sometimes that requires some punishment. So.
Understand.
Yeah.
Okay. Well, thank you very much, Judge. And as I said before, the citizens of Lorain County, Avon Lake and Lorain County, I think we do well having you as the judge in the future.
Thanks, Rudy.
Thank you very much for watching. Please give us some feedback on the show. You can ask questions, make comments. Our email addresses will appear on the bottom of the screen. If you are interested in being on the show, or you know someone who's interesting, who'd like to be on the show, please give us that contact information. And remember, seatbelts save lives. Thanks.
preceding program was presented to you by a community producer. The statements, views, and opinions expressed were not necessarily those of ALC TV or the City of Avon Lake.